Well, good afternoon, everybody. Pleased to say that I received an email yesterday from the author of this article, Richard Leo, and I will be sharing more details and information about the emails that he sent me. He sent me two, so I will investigate them further, and in the meantime, carry on with the second part of this article that was written back in 2016. So this is part two, strategies. This paragraph is entitled Strategies for Litigating False Confession Cases. To successfully put on a false confession defence, criminal defence attorneys must fashion persuasive answers to two separate but related questions. Why did your client falsely confess, and how do we know it is a false confession? These are not the same question, as some defence attorneys mistakenly assume. The importance of the first question is obvious. As survey studies have repeatedly shown, the idea that an innocent person, at least one who has not been physically tortured or is mentally ill, would confess to a crime he or she did not commit is highly counterintuitive, because it is considered by most lay people to be so irrational, self-destructive and contrary to self-interest as to defy common sense. The defence attorney must make the counterintuitive appear reasonable and understandable. The two primary explanations for why a person would falsely confess are that police interrogators manipulated or coerced the client into falsely confessing by using interrogation strategies and techniques that caused him or her to perceive that they had no meaningful chance but to accede to the demands of the interrogators, and that the client had personal characteristics, i.e. vulnerabilities, that rendered him or her susceptible to making a false confession. These explanations are not mutually exclusive, though most false confessions are believed by experts to be caused by police manipulation and coercion, not individual personality traits. To successfully explain why their client falsely confessed, criminal defence attorneys should first read the relevant literature on the social psychology of police interrogation and false confessions. There are some relatively brief, recent review of the field type essays that may be especially helpful, some more expansive book treatments, as well as older but more fundamental research articles. Familiarising oneself with the research literature will provide criminal defence lawyers with both a conceptual and verbal vocabulary to better describe the psychology of police interrogation and the various techniques and strategies that police employ, and to more effectively cross-examine police interrogators. In this age of electronic recording of interrogations, criminal defence attorneys can describe the techniques used and how and why they affected their client's perceptions during the interrogation and his decision to confess. Criminal defence attorneys should also familiarise themselves with police interrogation training manuals, which are good fodder for cross-examination and provide police with a series of do's and don'ts about proper interrogative practice, e.g. thoroughly investigate before you interrogate, don't wear a gun during interrogation, don't interrogate for longer than 4 hours, do not make threats and promises that have real consequences, and so on. Above all, when putting on a false confession defence, the criminal defence attorney needs to explain narratively as well as specifically how and why the interrogation techniques led the client to perceive that making a false confession made sense to him at that moment. Putting on a false confession defence is not easy, and we recommend that the criminal defence attorney go beyond trying to create reasonable doubt and instead go on the offensive. Well, That's like music to my ears. To be successful, the attorney will need to convince the jury that the client is innocent and that the confession is actually evidence of his innocence. As we explained below, a confession can be evidence of innocence when the post-admission narrative is disconfirmed by objective evidence. Sorry, let me start that paragraph again. As we explained below, a confession can be evidence of innocence when the post-admission narrative is disconfirmed by objective evidence, defies logic, and or is riddled with improbable errors. Convincing the jury will likely mean putting the client on the stand if possible and having him or explain how and why they were pressured or even tricked into making a false confession. A false confession defence is a substantive defence, not a procedural one, because jurors begin with a prima facie belief that confessions are true and that the defendant is probably guilty. The criminal defence attorney must remember that jurors did not go to law school and do not think like lawyers. They want to know whether your client is innocent or guilty, not whether there is reasonable doubt. And only a good explanation of how and why the interrogation techniques and psychological coercion made him or her falsely confess can convince them that your client is innocent. It is important for the jurors to understand both the pressure placed on the defendant and his psychological experience under interrogation pressure. To answer the second question above, how do we know the confession is false? Defence attorneys need to get outside the interrogation process and focus on the confession itself. They should compare the account their client gave after saying, in effect, "I did it," with the crime facts in order to determine whether their client's post-admission narrative reveals the presence or absence of incriminating knowledge, and whether the narrative is corroborated or disconfirmed by objective evidence. Again, yes, we are reminded, aren't we, of Judge Hamilton. You know, there were shell casings in the garage. You know, how did they get there? There must have been a shooting. Well, as Rowley Johnson testified, 3,000 bullets he probably fired in and around the garage. Okay, if the suspect committed the crime, he will possess non-public knowledge of both dramatic and mundane crime facts known only to the perpetrator, the police or the victim. The location of the weapon, items taken during the crime and specific aspects of the crime scene, such as the colour of paint on the wall or a pattern in the carpet. If the suspect did not commit the crime, he will not possess personal knowledge of the crime details unless he had pre-existing knowledge. The police contaminated him by educating him about the facts during the interrogation, or he was contaminated by a third party. Absent pre-existing knowledge or contamination, the probative value of crime facts and details provided in the suspect's post-admission narrative is directly proportionate to the likelihood that such details could not have been guessed by chance. The post-admission narratives of the guilty true confessor and the innocent false confessor will look different. The guilty suspect's post-admission narrative will not only likely demonstrate personal knowledge of crime facts, but will be able to lead police to new, missing, or derivative crime scene evidence, provide them with missing information, explain seemingly anomalous or otherwise inexplicable crime facts, and likely be corroborated by objective evidence. By contrast, the innocent suspect made to falsely confess will not be able to supply accurate crime details in his post-admission narrative unless he correctly guesses them. Rather interesting, isn't it, comparing that with Brendan? He just guessed and guessed and guessed, as Seth Waxman quite rightly put it. What's more, he will not be able to lead police to new, missing, or derivative evidence, or explain crime scene anomalies or other unique or unlikely aspects of the crime. Yes, I'd always like to ask Ken Kratz, Brendan led you to that bullet with the type of specificity that only a perpetrator of the crime would know. How would Brendan know to look under the compressor for that bullet? It just beggars belief. Anyway, instead, the innocent false confessor's narrative will not be corroborated by objective evidence. Instead, the innocent false confessor's post-admission narrative will probably be replete with guesses and errors and either be inconsistent with or contradicted by the objective case evidence. Well, again, we're simply describing Brendan's case there in full, aren't we? In short, the post-admission narrative of a suspect who confessed truthfully will tend to fit with the crime facts and physical evidence, whereas that of an innocent suspect will not. The fit between the suspect's post-admission narrative and the crime facts and objective evidence, therefore, provides a standard in many cases for evaluating the likely reliability of the suspect's statement. So, I think we all accept that quite happily, don't we? And we can see that, obviously, in Brendan's case, you have to cherry pick certain bits of information that the state had to do in order to simply try and get a story, because he is just all over the shop in terms of being inconsistent. So, to persuade a jury that the confession is false, the attorney, therefore, must argue that it does not fit and is in fact contradicted by the extrinsic case evidence, as well as by common sense and logic. The attorney must point out it reveals his client's ignorance of the true crime facts, except where the client provided details that were publicly known or results of contamination. If a contamination does not match the physical, medical, and other credible case evidence, then it is evidence of innocence, not guilt, regardless of whether the interrogation involved coercion. The psychological methods and strategies of interrogation explain how and why the client was made to falsely confess, but only a comparison of his post-admission narrative to the extrinsic evidence and non-public crime facts tell us why it is false or unreliable. To successfully litigate disputed confession evidence, criminal defence attorneys must put their strategies before trial. Voir dire is an excellent opportunity to ask potential jurors about their beliefs as to whether false confessions occur, whether police investigators make factual and interpretive mistakes when investigating crimes, and whether coercive police interrogation can cause innocent suspects to make false statements, even incriminating ones. Voir dire is thus an opportunity to educate potential jurors as well as exclude those who might be unreceptive to a false confession defence. Also, the preliminary hearing may be an opportunity to develop a false confession defence by locking the investigators into their account of what occurred during the interrogation, especially if the interrogation was not recorded, and illuminate their biases during the investigation of the case that led them to mistakenly classify your innocent client as guilty and therefore improperly subject him or her to a guilt presumptive accusatory interrogation. We realise that many criminal defence attorneys, for strategic reasons, might prefer not to aggressively litigate the confession at the preliminary hearing. But if your client really did falsely confess, then the confession is usually the centrepiece of the state's case against him or her, unless there is other mistaken, ambiguous, or fabricated evidence. And without it, there may be no probable cause to bind your client over for trial. In our opinion, it is important to remember that a successful false confession defence must be offensive, because at every step of the pre-trial process, third parties, i.e. police, prosecutors, judge, media, will presume your client's incriminating statements to be true and thus your client to be guilty, regardless of the methods used to obtain them. Again, if you want your false confession defense to succeed, you need to convince the judge and jury that your client is innocent. Finally, prior to trial, the criminal defense attorney may file a suppression motion to exclude his or her client's statement as involuntary under the 5th and 14th Amendments. Due process voluntary clauses or in violation of the Miranda warnings. If there is a Miranda issue, the attorney should, of course, aggressively litigate it, but Miranda is usually irrelevant to false confessions. Rather, a criminal defense attorney whose client has falsely confessed must try to get the confession suppressed as the involuntary product of a psychologically and legally coercive interrogation that violated due process by overbearing the client's will. Of course, no one really knows what an involuntary confession is, because voluntariness of the will is a metaphysical and ethereal concept, not directly observable, essentially a legal fiction. The criminal defense attorney must therefore convince the judge, as part of his or her argument, that the confession was legally involuntary, that it was elicited through overbearing and objectionable techniques such as false accusations, lies about evidence, lengthy interrogation, and implied or explicit promises and threats communicated as inducements, and that the client is factually innocent. To make these arguments, it will be necessary to identify the interrogation techniques the police used by referencing particular parts of the interrogation transcript or showing video clips of the interrogation, if the interrogation was recorded, and specifically how and why they caused your client to perceive that he had no meaningful choice but to comply with the demands and requests of the interrogators. To this end, it can also be helpful to question police interrogators about their interrogation training, which they will often claim to have forgotten or learned on the job, and specifically whether they were trained about psychological coercion, what they understand psychological coercion to be, and what they do to make sure they are not coercing confessions from their suspects. Attorneys should also cross-examine police investigators at the suppression hearing about whether they have been trained to recognise, understand and prevent false confessions, and again, what they do to avoid eliciting them. By revealing the investigator's ignorance, poor training, poor memory or inability to follow best practices, criminal defence attorneys can fashion a narrative about how and why the false confession occurred that does not rely on portraying the investigators as malicious or intentionally after a false confession, but rather as poorly trained, overzealous or careless, if not reckless. That's certainly an interesting line, isn't it? The more we find out about the behaviour of Wiegand and Fassbender, I think it was malicious and intentional, and I think they were directed to do so by Ken Kratz, but that's just my opinion. Other people might have their own personal opinion. Anyway, next paragraph. Contemporary interrogation reforms. The widespread recognition of the role that false confessions play in wrongful convictions has led to procedural reforms. One that has gained traction in the US is video recording of interrogations. Calls for recording of interrogations have been around for decades. Now, 20 states record interrogations in either specified or all felony cases. Recording interrogation has several benefits. It creates an objective and reviewable record of the interrogation, which should prevent investigators from making false claims about their exchanges with suspects. It should likewise prevent suspects from making their own specious claims. For example, that police failed to inform them of their rights and made threats and promises when none of that occurred. By inhibiting coercive practices, recording should promote truth-finding. Even if coercion occurs in an interrogation, a videotape serves as a transparent record that can be reviewed by attorneys, judges and juries, and should help prevent coerced confessions from becoming wrongful convictions. And where recording proves that investigators use practices geared toward gathering information in a respectful manner instead of one focused on coercing confessions, it should increase the public's confidence in police practices. We are strong proponents of recording interrogations and have authored a separate article on how to analyse recorded interrogations. Another approach to reforming interrogation procedures is to eliminate coercive practices in the first place. England and Wales took this step 30 years ago when lawmakers enacted the Police and Criminal Evidence Acts and the Codes of Practice in 1984. The Act required investigators to audiotape interviews with suspects and thereby increase accountability. Following this act, psychologists, academics and police investigators collaborated to produce a training document on the PEACE, P-E-A-C-E, interviewing method, and the police developed a course for implementing PEACE and making it standard practice. The acronym PEACE abbreviates the following principles. 1. Preparation and planning. 2. Engage the interviewee and explain the purpose of the interview. 3. Allow for an account from the interviewee. 4. Ensure that the interview is brought to a conclusion. And 5. Evaluate the interview data. As noted by Peirce and Johnson, the concept of investigative interviewing is intended to encourage a non-oppressive, non-coercive approach with an emphasis on information gathering rather than obtaining a confession per se. The PEACE technique differs in significant ways from the Reid technique. The Reid technique involves deceiving the suspect about the actual purpose of the interrogation. The Reid-trained investigators begin the interview by confidentially asserting that the suspect is guilty and that the purpose of the interview is to find out why he committed the crime or learn what other crimes he has committed to pursue some other fabricated purpose. The PEACE-trained interviewer tells the truth about the purpose of the interview. The Reid-trained interviewer interrupts the suspect's denials of guilt and only allows the suspect to give accounts of his actions in the post-admission phase. The PEACE-trained interviewer will allow the suspect to give a full account of his involvement or lack thereof. The Reid-trained interviewer is permitted and sometimes encouraged to use evidence ploys, including lying to the suspect about evidence of his guilt in an effort to secure a confession. The PEACE-trained interviewer is not permitted to claim false evidence against the suspect. The Reid-trained interviewer may be discouraged by their local police or culture from recording the interview, whereas the PEACE-trained interviewer is required to record it. More generally, the Reid-trained interviewer's purpose is to obtain a confession, and he presumes guilt. In contrast, the PEACE-trained interviewer's purpose is simply to gather information to solve the crime. A meta-analysis of research on interrogation techniques found that accusatorial techniques increased the likelihood of both true and false confessions, while information gathering ones increased the likelihood of true confessions without increasing the risk of false confessions. PEACE interview training has continued to evolve. For example, the Police Service of Ireland have adapted the PEACE technique to incorporate best practices in the interviewing of eyewitnesses. And the technique is beginning to gain a foothold in North American policing. Dr. Brent Snook, a psychologist at Memorial University in Atlantic Canada and an advocate of it, offers PEACE technique training to Canadian police officers. It is only a matter of time before PEACE training increases in popularity in the US. The PEACE technique is not an answer to all objections and interrogation, for it still relies on self-incrimination, a principle that is abhorrent to defence attorneys, but the technique appears to better protect against false confessions. Conclusion. Decades of empirical social science research has demonstrated that American police interrogators regularly elicit false confessions, and that false confessions often lead to the wrongful conviction of the innocent. Yet false confessions remain counterintuitive to most most lay people, police, prosecutors and judges. False confessions bias police investigators, criminal justice officials, excuse me, and triers of fact against the defendant at every stage of the criminal process. Studies have repeatedly shown that if a confession is introduced into evidence at trial, even if it is obtained under questionable conditions, supported by no independent evidence, contradicted by substantial evidence, and ultimately proven false, it is highly likely to lead to a wrongful conviction. Nevertheless, though, they are not easy to mount. So, false confession defences have never been more winnable. So let me say that again. Nevertheless, though they are not easy to mount, false confession defences have never been more winnable. Our increasing knowledge of the causes, characteristics and consequences of false confessions enable criminal defence attorneys to more effectively litigate disputed confession cases. This article has sought in part to suggest ways that they can use this knowledge in these cases. American police interrogation appears to be slowly moving away from guilt presumptive and accusatory Reed-style interrogation toward more investigative interviewing approaches. It is incumbent upon criminal defence attorneys to be well versed in the social science research on interrogation and confession, as well as the leading police interrogation training manuals, in order to aggressively and effectively litigate false confession cases and thereby prevent innocent and or overcharged defendants from being defendants from being erroneously convicted. And that concludes that particular article. Well, thank you for joining. And as I say, I will be doing some review of some of the information that Dr. Richard Leo sent me. One of the things that I have asked is that, based on the Drizzen and Leo article of 2004, this is an article in 2016. I did ask him, has videotaping been taken up by most states? He said that between 25 and 26 states now have video recording of interrogations. So that it appears that it is making a difference, and surely the way in which the police interrogate can make a huge difference. I don't think any of us would have had any trouble persuading Brendan Dassey to have sort of confessed to doing anything. I don't think there would have been any trouble, given the power and authority of police investigators in that situation. You know, when they tell him that he's going to get charged, people in the office, they want to charge him. They're wondering why he hasn't even been charged yet, and then you get them telling him that Stephen Avery is going to be telling us all about what you did, and it's all fabricated. Anyway, we'll stop it there and catch you again soon with, as I say, some more updates from Mr. Leo and Saul Kassan. Bye for now.